This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviat. Tonight we're taking your calls and questions all about injuries. So that's everything from car accidents to medical malpractice. Maybe a toy that you bought for someone actually injured them over the holidays. Call in your questions. The 31 Law Call number 256-536-0077. You can also email your questions. You can send an email question anytime, any day of the week. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we pull out some of your email questions, and we will have some of those tonight. Getting us started tonight, Michael Timberlake's here from Timberlake and League. Good to have you here tonight.
It's good to be here.
We got both of y'all tonight. We got Timberlake and League here
We brought
tonight.
the expert. We brought the talent. I'm just here to serve up questions.
Getting everybody started the first of the year. So the first live call-in show, calling your questions all about injuries. And getting us started tonight, we've got the You Make the Law Call video. So we've got some video that we pull from YouTube, and we play it and we take a look. Is this something that you might, if this happened to you, okay, so it's a ditch and it's dirty water, and this actually turns out to be deeper than you think it's going to be. First two guys, no problem. Everybody's fine. Okay, now it's deeper than you thought it was, isn't it? So if you fell in something in your town, we've got some drainage ditches around Huntsville. If you got in those for whatever reason, and she gets out at the end. You're going to see at the very end.
Good.
Yeah, so everybody survives this, but it's nasty in the meantime.
That's like a not good lazy river.
Not good lazy river. If something like that happens to you, I mean, you're probably not supposed to be jumping over that, probably not supposed to be getting in that. Is that a case, or what would you need to know to figure out if somebody's got a suit with that?
Well, I mean, kind of the first thing we tell people in any environment, you're injured on somebody else's property, just because it happens on their property doesn't make that property owner responsible for the injury.
Okay.
And in every situation like this, there are defenses that the property owner will present or has available to them if their case goes to court. And basically, if a hazard on a property is open and obvious, such that somebody could see it and be and notice the danger of it, and they're injured as a result of that, then it's something that the property owner is not responsible for their injuries. In this situation, it was open, it was obvious. She didn't think it was going to be that deep, but that's still going to be a tough case. Yeah,
it seemed pretty clear. That's not something that you're supposed to be doing.
Right.
Okay, we've got both Michael Timberlake and Will League. Will, good to have you here answering questions with us live in the studio tonight.
All right. Hello, Sharon. Michael, how are you guys?
Doing great. Talk a little, sometimes people don't know what kinds of cases personal injury attorneys handle. Give us an idea what personal injury cases involve.
Well, we're starting, Michael and I have been practicing together for almost 25 years, and we do, right? So it's getting a little bit up there. But, we do all types of litigation, medical malpractice, car wrecks, workers' compensation, premises liability, what he was just looking at. And lately you hear about the military, the burn pit cases, the death cases, coming out of exposure for burn pits across, overseas. You've got the earplug cases, Johnson & Johnson. So when you look at some of these class action things we're looking at, they're more of a mass tort situation. So we want to start off today or this year with all about injuries, and so that's the topic today, products liability. When you call Michael or I or our firm, something bad's happened, so, it's not great to talk to us because it means you need help in some way. And so it's a pretty broad range of cases we try. Michael, we've seen changes in the law. What have you seen most in the last 10 years?
Well, I mean, basically, if you're injured in some way and you think it could be somebody else's fault, we'll try to figure out a way to try to help you. And if we can't help you, we'll tell you. The law does change dramatically over the years. Kind of the core tenets of what we do in terms of negligence cases or medical cases, are all kind of the same. But there's a lot of things that change in terms of the reimbursement rates for insurance companies, court cases that come out that make it harder to prevail in cases that are in favor of businesses or insurance companies. And we've seen kind of that trend for the last 10, 15 years.
What does it cost to come see somebody to just walk through the basics of what's happening in your case?
Well, I will talk to you for free on any occasion. And will too.
Will too.
There's no charge for what we do. It's a contingency fee basis, which means we don't get paid until we win. So we're taking a risk with you. Lawyers, evaluate the cases, determine whether or not there's likelihood of liability, recovery, and you want to go through all those factors to determine whether or not the case is, is reasonable to pursue. Because if it's not, juries won't react to that, which is fine, and that's how it should be. But you and the lawyers sit down, talk about your case, and then go forward. For example, we just saw that video. Now the lady, I think it was a lady, she stepped into that water, was contributorily negligent because she made a suspect decision in putting herself in peril. But Michael and I have handled death cases where, let's say there's a bridge closed and there's a flood and the car goes over that, or it was not blocked off properly, or it wasn't, the occupants of the vehicle were not on notice, pulled onto the bridge, they're swept away, and it gets serious fast, and those occupants died. So while, yes, that was kind of a cute video, she was swept away and she got out, entering water that's moving, whether you're on foot or in a car, we've seen there are tragic consequences. So, the cases we look at are A to Z from all types of injuries or death, and it's interesting business to be in, and oftentimes a sad one.
Yeah, I mean, some of the more complex cases that we see a lot of times, what we'll do is we'll sit down and we'll meet with the people. We try to meet with the folks in person, so that we can get their story and find out what they have to say. And I think that's important, that you're able to talk to your lawyer directly, make sure that they understand exactly what's going on. And then sometimes we'll say we need medical records to investigate this. We'll investigate it on our own. We'll go out to the scene. We'll do things to try to figure out what we can do to help folks. We don't charge for that at all. And if there is no recovery, then you won't ever be charged for any of that time. No home visit charges or anything like that. We're going to, look at it, and if we don't think we can help you, we'll tell you, and we'll explain to you our rationale for why we can't do that. Or we'll take your case on, and we'll take that, like Will said, on a contingency fee basis, which means you don't pay us anything unless and until we collect.
You're talking about meeting with somebody personally. I think people would be surprised that there are a lot of law firms out there that are either doing Zoom or they'll sign you up over the phone, and you don't meet with a live person. You may not meet with that, right?
Yeah, I mean, we don't have any case managers.
Yeah.
I mean, we have lawyers.
Y'all are doing the case. You have lawyers. Don't be surprised. Other situations are not necessarily that way. Okay, we've got callers waiting. We've got Brenda on the line with a question from Harvest. Hi, Brenda. Thanks for calling. What's your question tonight?
Hello. Yes,
Hi.
Thank you for taking my call.
You bet.
My mother was in a store, grocery store, in one of the mobilized carts, and she went to reach for an item on a shelf, and the cart tumbled over with her in it.
Ooh.
I wanted to know if there is any liability on the store part or on the manufacturer of the go-kart.
Okay, don't leave us just yet, because they may have some follow-up questions for you.
Yeah, I mean, that's a good thing. Will, on the products end of it, what are they looking at?
Well, basically, if it's a products liability case, and I assume it was the store's cart, but if a manufacturer designer places an item in the stream of commerce that is unreasonably dangerous, then there may be a products liability action. In this particular case, your mom was using the cart. If she was using the cart for its intended purpose, for example, she's going up through the grocery store trying to get something and it malfunctions in some way, she's injured, that may be a case. But let's say you and your mom decided they were going to do some NASCAR around the grocery store, and she's racing all the other older ladies, and they wreck. That's not using the cart for its intended purpose. Probably it wasn't designed to be to race around the store. But if she was using it again for intended purpose, and they placed the product in the stream of commerce, and it was defective or unreasonably dangerous, and that gives rise to an Alabama extended manufacturer's liability doctrine case, which is a mouthful to say, but basically, product hurts you, and you were doing what you're supposed to do with the product.
Brenda, are you still with us? Tell us, did your mom have injuries? What kind of injuries did she have?
Yes, she later had a gash head injury.
Yeah.
Brenda, did you guys retain the cart? Do you have it? Do they have it? Because any products liability case, you need that product.
Oh, the store has it.
Okay.
Yeah, and that's what,
yeah,
right?
Michael,
Because you've borrowed the. What do you do to preserve your evidence in a situation like that? You can't keep their cart.
Well, the most important thing you can do is put the store on notice that there was an issue, and you can send them a letter saying basically, and we do this in a lot of type cases. It can be any kind of case where you need evidence preserved, and you notify the other party that, look, we're investigating this, we're looking into this, you need to preserve any evidence that may be relevant to this situation. You have to define the injury, the type of situation, but then they're on notice that they have to preserve that evidence. And if they don't preserve that evidence with the knowledge that you're investigating and could pursue litigation, then it can be very disadvantageous for them when the case goes to court. You basically get in a situation where the jury is instructed that you can presume that they did something wrong because they destroyed evidence. And that can be very, very powerful in any kind of case when evidence is destroyed.
We've got another caller. We've got Teresa on the line with a question from Florence. Hi, Teresa. Thanks for calling. What's your question tonight?
Yes. My question is, I was hurt on the job with an on-the-job injury.
Okay.
I have been receiving workman's comp, which has been 66% of my salary for 2 years, which is $3,000.
Okay.
And last week, my adjuster told me that they were going to have to settle with me. I'm 62 years old, and I'll never be able to go back to work again. And my question was, what is a fair settlement?
Good question. How do you know what it's worth?
Well, one, I would encourage you to talk to a lawyer about your situation because they can tell you, or we can tell you more details about the situation than I can tell you on a television show. But basically, if you are 62 years old and you have suffered an injury that's compensable and you are not going to be able to work again, the fair argument that I would say is that you're totally disabled. Total disability under workers' compensation in Alabama provides for 2/3 of your average weekly wage for the remainder of your lifetime. And if you go to court and they prove that, they would pay you that week by week by week by week. One of the things, in addition to providing you advice on what the law is and examining the facts of your case, a lawyer may be able to negotiate a lump sum payment of those future benefits so that you receive some lump sum for a permanent total award under workers' compensation now, and you're not waiting on checks in the future.
They're telling us to take a break. Let's take a break. We'll be right back answering more of your questions. Call in the 31 Law Call number 256-536-0077. Be right back.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Dovia. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
And welcome back to 31 Law Call. I'm Sharon Dovia. Tonight we're taking your calls and questions all about injuries. We've got with us both Michael Timberlake and Will League. Timberlake and League in the house answering questions. We've got Dexter on the line with a question from Florence. Hi, Dexter. Thanks for calling. What's your question tonight?
Yes, ma'am. My question is, I want to know if I got a malpractice suit.
Okay. What happened?
Less than 2 years ago, I broke my femur in half on that ice storm we had.
Okay.
They put the wrong screws in my leg and my knee, and the screws went all the way through to the other side of my bone, and I couldn't bend my knee.
Ooh.
And then they had to take them out, and they left them out, but they left one long one in it. They didn't put no more screws back in it. So my knee pops and carries on, and it gives out on me.
Okay.
I was wondering if I might have a case or not.
Okay, and it's coming up on 2 years.
Coming up, yeah.
If that's important.
Right,
okay.
Dexter, you'll have, like Sharon said, you got 2 years from the date of your injury to file this, so you want to make sure that you get within that time frame first. If you broke your femur, they probably put what's called an intramedullary rod in, where they go in, put that rod in your femur to stabilize that fracture and put some screws across there to hold it in place for a while. If, like you say, they use the wrong type of screws, the question then becomes, is that a breach of the standard of care by using those screws? And if they breach the standard of care, was that the proximate cause of any additional injury that you had or problems you had recovering from this? So there's a two-part process. Were they negligent? Did they breach the standard of care? And that'll come in through expert testimony, through another similarly situated physician that has to come in and testify, yes, I'm Dr. B. Dr. A breached standard of care by using those type of screws, and the causation or the proximate cause of your injury was based on those improper screws being used. So you'd have to answer both those questions in the affirmative for that to be a medical malpractice case. Now, Michael, we often talk to our clients about the economics of pursuing and filing medical malpractice cases. We're one of the only firms that still do medical malpractice cases in North Alabama, and what's the difficulty with that?
Yeah, I mean, we tell people, look, that it's hard for me to diagnose anything over the phone. So, the first thing you need to do, especially if you're on a short time frame, is get the records from all the doctors that treated you from this situation. Then, like Will said, you've got to assess. One is the liability. What did the doctor do wrong? Second, you got to assess whether there was causation, whether what they did wrong caused a problem. That can be difficult when there's a pre-existing trauma or an underlying trauma that caused the whole thing. Can be difficult for doctors to say what caused what. And then in the situation, you've got to have an injury that is significant enough to justify legal action, to make it so that legal action can benefit you. You're looking at expert costs, you're looking at fees, you're looking at court costs, you're looking at having to go forward with extensive litigation and mostly to trial. And so you can, $50,000, $75,000, $100,000 in these cases.
Woo.
Right. And without a significant injury, sometimes the cases just aren't economically feasible to pursue.
Okay, so the 2-year time frame, he may not have known that they put in the wrong stuff for a while, right? So what are you looking at for that 2-year window?
If he's still there, I'd like to know how he knew that they were the wrong size screws.
Dexter, are you still with us? How do you know they were the wrong?
Ma'am, they took and screwed them all the way through my other side of my knee, and I couldn't bend my knee when I was going to therapy.
Did they tell you we put in the wrong screws?
Yeah, and the doctor told me that they was the wrong screws.
Okay.
Well,
I mean, if they had it to where your knee was immobile when you're trying to perform therapy, it's any joint, you need it to be mobile to get back to full strength or even partial strength. And so you would need a physician to testify, yes, they were the wrong screws, physical therapist to testify, the physical therapy recovery of an injury like this usually goes like this, but because of that wrong screw, you need another physician to come in to testify the nature and extent or difficulty you had recovering and what's the delta between what the recovery you would have had with the correct screw and what was actually how you recovered with the wrong medical device inserted.
okay. Dexter, get your records and go see somebody and don't
Absolutely.
wait. Don't
Don't wait.
We got this email question in. This came in from Bucky. Bucky had written in, if I'm ever sued, what assets are protected from a judgment? I only have a primary house, 1 car, a 401k plan, and less than $10,000 in cash in the credit union. Just wondering if I need to reevaluate my liability coverage. Thank you. Okay, can you talk? I know that's a pretty complicated thing there, but
first of all, assets are not protected.
Okay.
So there aren't any kind of assets that are protected in Alabama. So you're really kind of in a situation where if you get hit with a judgment, you can file for bankruptcy. There's some provisions in there for homestead, but it's not really a lot. So if you don't have any insurance and you get hit with a judgment, then you're going to be out of pocket, and all your personal assets are at risk. So, they need insurance, right?
They do. They do. I mean, you want to check. I think to try and evaluate what your liability insurance is. It's first off, it's mandatory. It's against the law. If you get pulled over, your driver's license can be revoked, your registration for your car, things like that. But if you don't have enough, if you have assets and you're going cheap on insurance and you don't have enough, your personal assets can be at risk. Sometimes, let's say it's punitive damages. There's compensatory damages, which are medical bills, pain and suffering, lost wages, things to kind of put you back to where you were. Oftentimes, if there is a bankruptcy, those might be protected. However, punitive damages, you're drinking and driving, texting, speeding, anything that would give rise to punitive damages, then those are not protected under bankruptcy or any type of insurance policy. Insurance policies sometimes pay those, but if you don't have enough coverage, then your personal assets are at risk. Also look at your underinsured motorist coverage. That's to insure you against the other person if they don't have coverage or don't have enough coverage. So I get it, who wants to sit down and read all that fine print? But if you don't have enough liability coverage, your assets could be seriously exposed. If you don't have enough underinsured motorist coverage, which is some of the cheapest insurance you can buy, that's to protect you against an unknown danger. And I have too many clients come in and say, I signed that waiver, and if you sign that waiver, you're done. There's no recovery to be made. So make sure you go back over that and make sure you have enough liability and underinsured motorist coverage benefits.
Yeah, I mean, think about what your assets are, what the equity is in your house, what you have in your bank, then make a decision about how much liability insurance coverage you want in front of you before somebody starts looking at those.
Gotcha. Let's talk a little bit about class actions. So some of the things that Will was talking about before. He was talking about burn pit in Afghanistan, and he's talking about talcum powder in Camp Lejeune, and some of those things that we maybe see stories about. There are class actions going on. So if we see a lot of commercials and there are numbers for law offices way off somewhere else. If I've been one of the victims of the talcum powder problem, do I call the law firms that are specializing in it, or do I need somebody that's local? Or what do you recommend?
Well, I mean, if somebody that's local is going to be able to meet with you in person, talk to you about your situation, and then help explain it to you and help with you in person with any documents that need to be filled out. Now we handle these cases, and we handle different types of things. Lejeune is a statutory compensation scheme. The other things are mass tort schemes, and sometimes they're just individual cases that are all bundled together. So you want to talk with somebody that's local. A lot of times local firms will work with other firms out of the state to push these cases along and use the economy of scale, but you want to talk to somebody in town.
Does that mean they're going to...
For example, in Lejeune, there's $9.7 billion in a fund, and a lot of those servicemen are getting cancer, and you determine, okay, look at the medical records, do they qualify for that particular fund? So you need a local attorney who's familiar with your medical, take the depositions of your doctors to go ahead and submit those, and it's a complicated process. With the talcum powder case, Timber, and we handled a lot of those fin cases way back in the day, and basically your local attorneys will work with some of the other attorneys, but you want somebody that can evaluate your medical records, take your doctor's depositions, and you want somebody at home plate, for your particular case.
It's not going to cost you more out of your cut.
It's not going to cost you more,
Okay.
and you get some hometown flavor, and somebody in home may know the doctors to be able to get the evidence you need.
Gotcha. Let's take a break. Be right back. If you didn't get your questions answered tonight, here's how to get in touch with personal injury attorneys Michael Timberlake and Will League. They are with Timberlake and League in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way. And somebody will also be on the Midday News tomorrow, Monday.
Sharon practices family law right here in Huntsville. Her number is 256-539-7337. SharonFamilyLaw.com. She does child custody, divorce, all those types of things that deal with family law.
Thank you all for your calls and questions. Good to be back live again, to have both the big dogs from Timberlake and League live in-house. Have a safe week, and we'll see you next week.